Good afternoon, everybody. Welcome to CUHK Law. Welcome to the third of our 2024-2025 Greater China Legal History seminars. My name is Lutz Christian Wolf, and I'm chairing this seminar today. We have a great speaker today, but before I introduce him, I would like to mention that he has kindly agreed to leave some time for questions at the end of our seminar. If you do have questions, please use the chat function, send them over to me or to Jay Wong, and I will then read them out on your behalf so that we have a good discussion at the end, hopefully. Today's seminar is titled How to Own a Forest, Shareholding, Futures Contracts, and Ancestral Trusts in Southern China, and it discusses very important issues during Ming and Qing dynasty in China. Our speaker is Professor Ian Miller. He was a speaker before, and that's why we invited him back, because the last seminar was so interesting and fascinating. We got lots of positive feedback. Professor Miller is an associate professor of history at St. John's University in New York, where he teaches East Asian history, world history, and environmental history. He is the author of not less than 2 books already. The first one was Fur and Empire, The Transformation of Forests in Early Modern China, which appeared in 2020. And the second book is an edited volume titled The Cultivated Forest, People and Woodlands in Asian History, was published 2022. Professor Miller received his PhD in History and East Asian Languages from Harvard University in 2015. Then, between 2016 and 2018, he was a program fellow in agrarian studies at Yale University and a visiting scholar at the Max Planck Center for History of Science in Berlin. In 2021, he received a fellowship from the National Endowment for the Humanities to begin work on ancestral shade. And as mentioned, he is now an associate professor of history at St. John's University in New York. That's it. I hope we will have an interesting talk and an even more interesting discussion afterwards. And with this, over to you, Professor Miller.
Thank you, Professor Wolf. And thank you again to you and to Stephen Gallagher for the invitation to come back to your seminar series. It's been a little bit less than a year. It's hard to believe, but I had a great time the last time that I was here. Hopefully, if you invite me again, I can do it in person in Hong Kong. I think that would be wonderful. But I learned a great deal from the last time around, and so I'm very happy to be back. And I hope that this is an interesting talk. I think that it builds in some ways on what I had to say last year. I'd like to thank Jay Wong as well for all the coordination work. And I think with that, I'm going to go ahead and share my screen. If this... This is not allowing me to see this. Why is it not? Okay.
While you're sharing your screen, I should mention that Professor Miller is joining us from New York, where it's close to midnight at the moment. And this is, well, a special reason to thank him for giving this seminar. All right, here we go.
Is my screen sharing now? Yes?
Yes. If you could.
Okay, wonderful. Okay, yeah, so my talk this time, as Professor Wolf mentioned, is titled How to Own a Forest, Shareholding, Futures Contracts, and Ancestral Trusts in Southern China. And I'm mostly going to talk about this issue of ownership as it relates to shareholding. I maybe was a little bit ambitious in trying to push into some areas that I'm working on now on ancestral trusts that I will speculate a little bit on. But I'm mostly interested in this question of ownership. And if this seems like a strange or provocative title, I think that this is intentional. I'm using it to highlight two things that I think are considered now very normal and banal almost, but that are not historically simple. And one of them is this question of ownership, in particular land ownership. And the second is forests. And so if I start in this very abstract air, asking what is a forest or what is ownership, I think I'm going to lose the thread very quickly. And so I want to start with a very concrete problem. So I'm a forest historian. I work with forests. My department chair likes to joke that I'm a tree guy. So I suppose I am a tree guy, but mostly my job is to read documents. I'm a document guy. And so these are what some of the documents that I am working with look like. So these first two come from land registers from Huizhou Prefecture, the historical Huizhou Prefecture, which is now split between two provinces. And they're two different forms of what are sometimes called fish scale cadasters. But they're basically they're land registration documents for the purpose of taxation, as well as from the landholder's perspective for the purpose of having a central registry of title. And so you can see that there are two different ways that forests are depicted in these documents. In the left one, each plot is depicted as a sort of square or rectilinear area, and the boundaries are recorded. And then to the left-hand side of each of these four plots, there is some information about how they are subdivided into shares. And that's an issue that I will return to. The right-hand one is another form of these sort of fish scale cadasters that I have taken the liberty of coloring to make it easier to see the different sorts of landholding that are registered in these. And so the light green in the center are fields. These are paddy rice fields. And around the periphery, these dark green areas are forests. And there are a variety of other land types. Ponds and orchards and wasteland and tombs are in red. And it's actually the tombs that I spoke about last time that I was here when I talked about feng shui. So here are some more of the documents that I work with. On the left hand, we have a land deed for the sale of a forest. And this is a fairly standard format. And I've seen literally hundreds or thousands of these. And on the right-hand side, this is a very interesting document from the Longchuan County Archives, which have since been reprinted. And so what we're seeing here is that probably a county clerk, we're not entirely sure who drew this diagram, but has gone out to draw a diagram of a plot where there has been some sort of dispute over the disposition, the ownership, the use of these trees and this forest that are depicted there. And so these are, I think, while their specifics may be a little bit unfamiliar to you, in general form, these are documents that I think that historians and lawyers have in common. And so they probably don't pose a real problem to you. This is how you own a forest, right? You register it with the government, and then you document any changes in the title with a deed, and you challenge any rival claims that should emerge to your ownership in court. So there you go. My talk is over. That's how you own a forest. But that's actually not the historical problem. The historical problem is that the documentary record is inconsistent. So we have loads of these documents of land deeds, of litigation records, not as many of these land registration documents, but especially loads of deeds and litigation from the early 20th century, from the 19th century, from the 18th century, going back about as far as, say, the 1740s, 1750s. We used to have a few from a handful of places, and now we have heaps of them from loads of places. That's the technical term. We have heaps of them. To get into, a little bit more Specificity in terms of how many, I was just in Yongtai County in Fujian in late this spring for a document workshop. And from that county alone, the team at Xiamen University has found hundreds of thousands of documents. They come in boxes like this. They're in people's houses, and they are organized according to the system that made sense for whomever originally was using these documents, and they've been retained in many cases by their descendants. And there are literally hundreds of thousands of them still extant. And in Yongtai is a very mountainous county, a heavily forested county. And so probably a good 50% of these, 50% of them deal with forests in some way. And there are tens of thousands more from Longchuan County in Zhejiang, from Shicang County in Zhejiang. There are probably not quite as many, but another thousands or tens of thousands more from the Qingshui River Valley in Guizhou. And there are doubtless thousands more from other places that have yet to be discovered or that have been discovered and I'm not yet aware of. And so this is really a revolutionary change in legal history, in forest history, and social history that is unfolding as we speak. As I mentioned, when I was in graduate school, which is maybe longer ago than I would like to think, but was not that long ago, there were not that many of these documents that were known. And so it's really been in the last 10, 15 years that most of these repositories, these historical sort of saved documents have been rediscovered by historians and made public. There are now, I think, over 50 volumes published out of Xiamen with these documents that I was looking at in Yongtai. And so this enormous volume of legal history documents, of contracts, of deeds, of litigation materials is in the process of revolutionizing Chinese legal history. There's really no other way to put it. And so the scholars at the center of this have one problem, which is a problem of excess. There are more documents than they or than we can easily read, and they are in the process of using them to puzzle out various ways that people owned, rented, subdivided, disputed, and otherwise hashed out the control of their forests. And I'm frankly still playing catch up on this side of things. But the flip side of this is that before about 1750, we have very few documents. And the ones that we have are overwhelmingly from just one or two regions. Overwhelmingly, they're from Huizhou Prefecture, which is a historical prefecture which is now divided between southern Anhui and northeastern Jiangxi. And there are very similar documents to what we're seeing here in Yongtai, dating back to the early 1500s. And there are smaller numbers dating back to about 1200, and then they stop. Before 1200, we have very few forest deeds and practically no land deeds at all. And it is not just the private contractual record that stops around 1200. The public record stops around that time as well. Something that I documented in my first book for an empire is that in the late 1100s, so the late 12th century, there are thousands of acres of forests in the tax records. We don't have the original tax records, but we have versions of them transcribed into later materials. And there are tens of thousands of acres, tens of thousands of mu of forests registered in these tax documents. If we go back a century to the early 1100s, there are essentially none. So this is a second interesting historical problem. One is the problem of excess, and then the other is the problem of absence. And so we have to ask, in other words, how did we go from having almost no records of forests to having a lot of records, quite a lot of records? And so another way of asking this question is, why did people decide that it was necessary to record their use of forests? And I think the answer to this is pretty clearly that something about property rights is going on. That the reason that they felt the need to record their use of forests is because they felt the need to secure their property rights to those lands and to the trees that stood on them. So to better understand this problem, let's look at a typical document from about midway through our record. So I mentioned that we have documents all the way up to the end of Imperial China, and in fact, even into the Republic of China period, and we have them going back to about 1200. So this is a document from the early 1500s. And so I will read it because I think that this is a useful one. And so I'm going to read the whole thing. And so it says that Tanjing previously contributed to the collective purchase of Hu Yuanqing's cadastral registration and the associated forest plot in Bao number 5 in the area called East Spring. And together with his uncles Tan Yongxian and Tan Yongfang, Tanjing also bought an unspecified number of sections on this plot that had been planted with fir, with shanmu, with shamu, a type of tree, right, by Tangong and his cousin Hongjing. And Tanjing also collaborated with Tan Qi to plant another section with fir, and he worked with a group of unspecified people to plant another forest section with seedlings. And so today, what he is doing with this deed is he is selling the above forest plot and all the other items held under his name, including all shares of fir seedlings that he either planted or purchased. And these items are included with the deed and sold to be placed under his uncle Tan Yongxian's name. And so it's written that this will consolidate ownership for easier management. The parties met face to face and agreed on a current value of 1.7 taels of silver. And the document was exchanged. And so here is the deed summarized. It starts with the source of title, the most recent purchase or inheritance that gave the current owner this property. And so in this case, Tanjing purchased a cadastral registration. So a registration in one of these tax books, in one of these registration books that I showed you earlier, and the associated plot. And so in other deeds, there are other sources of title cited. Someone might have inherited the property, or it much less often, but occasionally you will see them claiming a property that they claim to be the first person to have taken possession of. And so we have at least the proximate source of title, if not the entire chain of title cited here. Next, we have the location of the property, which is given in both its local terminology, so it's locally called East Spring, Dongyuan, and also in its official place in the land records, which will allow you to locate it in those types of fish scale cadasters that I just showed you. So in this case, it's just telling you Bao number 5. This is, below the level of the district. But in some cases, it will give you the entire administrative hierarchy. So it will say in this county, in this district, in this Bao, in this village. And now we have shareholding. And so what we can see from Tanjing's deed is that there are clearly two different types of shares. First of all, he got one type of shares by putting together money with his uncles to buy the cadastral registration that gave them ownership of this plot. And so these you will see in some documents in Huizhou referred to as owner shares, as zhufen. And then in other cases, they derive from inheritance. And the owner shares, critically, if we look, it's not clear from this document itself, but if we look at other documents, they give rights to the plot itself, which are retained permanently until sold, so the underlying land. They also give rights to any trees that are grown on the plot, even if the holder of the owner share did not plant those trees himself. And there are some details that we can work out about this in terms of how many of these shares go to the owner shares and how many go to the labor shares. But in every case, I've seen the owner of the underlying plot takes at least a 3 out of 10 share of the timber, even if he did not contribute to planting that timber. And so next, there are labor shares, which again, in some documents are literally called 利分, labor shares, which are shares which are obtained either by contributing labor to planting trees or by purchase. And these give rights only to the trees on the plot. And so when the trees are cut and the logs are sold, what happens then is that the profits from this are divided among both the owners of the owner shares and the owners of the labor shares according to a pre-established ratio. And then the owners retain ownership of the plot. The owners of labor shares are no longer holding any ownership stake in the plot whatsoever, unless they then plant more trees in it. Now we have the sale and the price. A sort of minor note that I think is interesting, to the extent that I've been able to look into this, the price, the main value of the plot is in the trees rather than in the underlying land that the trees stand on. And I think that this is an area actually where the new documents will allow much more detail in analyzing how much of the value is in which of those components. But I think there are two more important things to note here. The first, which is something that my mentor, Michael Soni, has emphasized quite a bit in talking about the Yongtai documents, is that what is actually bought and sold here is the document. And the land title is very much tied to these documents. What does the forest owner actually own? He owns the deed and the cadastral registration. The forest plot itself and the timber standing on the plot are seen as attached to the document. And so possession of the forest hinges to some real degree on possession of the documentation of the forest. And so this is actually something that we see in any cases where ownership is contested, is that the people who are contesting the ownership, in almost every circumstance, even if they have other ways that they're contesting the claim, they will produce a document of some sort, even if it's a falsified document, as the basis of their claim. The second note that I want to make here is that forest shares emerge through, I think, at least three distinct processes. So the most powerful owner shares pass through inheritance. And through the process of inheritance, we see shareholding through fission. So what does this mean? If there was an original owner who planted the entire, who owns the entire plot by himself, and he planted the entire plot by himself, and then he has 2 sons, we get 2 shares. If he has 7 sons, we get 7 shares. And then in subsequent generations, we will see these sometimes subdivided into even smaller shares in the grandsons or the great-grandsons generation. And so unlike farmland, which was typically divided up into smaller plots, or the individual plots were parceled out, forests were often retained as large plots that were subdivided by shares rather than by physical partition. And ultimately, if we trace these claims back far enough, they must derive from an original claim through occupation of the land. The second mechanism that gives us shares to forests is through labor. And I think that what the documentary record here shows is that labor shares largely emerge through almost the opposite process, which is through fusion. And so what you often see is that 2 or more laborers, or a laborer and an owner, decide to pool their resources, pool their actions, and they agree on a way of splitting up the eventual profits of their work. But basically they form a partnership, and that partnership will then agree to subdivide the eventual profits through shares. And so this is a second way that we see shares emerge. And the third way that we see shares emerge is through advance sale. So all of these sales could be sold before the profits from the forest were realized by harvesting the timber. And this included the owner shares as well as the labor shares. Sometimes selling these shares in advance led to consolidation, which is something that we saw in Tan Jing's case, right? He sold his shares to his uncle, who had been a shareholder in the original purchase, and so now his uncle has consolidated ownership. But actually, I think what we see more often is further subdivision through the advanced sale of shares, where someone maybe owns a half share in a forest and they sell half of that share to a third party. And so this is another way that that shareholding emerges. And sometimes maybe the most interesting thing is that shares in different properties were parceled together, leading to complex amalgamations that basically look like an early form of investment portfolio, where you have one owner who has, say, a half share of Forest A and a 1/3 share of Forest B and a 1/8 share of Forest C, selling all of these things with one document. And so this looks almost like, a piece of a mutual fund or something like that, some sort of investment portfolio. And as these become more complex at least in Huizhou, there are a few really fascinating things that happen. First of all, we see a separation not only of ownership and labor, but actually into three strata of ownership, management, and labor, where there are specialized managers hired in some cases to deal with these portfolios. And there are a variety of new documents that emerge outlining the rights and responsibilities of laborer and managers, especially for things like firefighting, which is very important in the forests, as well as policing theft and things like this. And there are also some new documents that emerge that outline the makeup and the responsibilities of the ownership group. And so, as Joseph McDermott has pointed out, what we're seeing emerge here is something like a primitive futures market. Now, this is not all. There are a lot more complications. And so anyone who has worked in sort of historical Chinese legal documents, I think will probably be familiar with some of, if not all, of these additional complications because they're not necessarily unique to forests. So there is long-term, or it's sometimes called permanent tenancy in the Chinese lexicon. It's called two lords of a field or three lords of a field, 一田两主, 一田三主. And so this is another way that passive investing and active management could be separated out from one another. And we can talk more about that if you're interested later on. There are conditional sales, dian in Chinese, dian or diandang, or sometimes called huomai, so living sales, which are used for the renegotiation of the price or value of the property after it's sold, with the original owner retaining some sort of hold on it. In the Yongtai documents, there are, in many cases, dozens of increasingly sort of frantic final sales that are still not really final, and that original owner will come back and sell it again. And this is a question that has rather stymied legal historians as far as I can tell, and I'm going to sort of elide this discussion for now, but maybe come back to it a little bit later. And we have pass-through tax accounts, or pass-through accounts of several varieties. And here again, I think there are at least three distinct ways that these pass-through accounts emerge. The first was these pass-through tax accounts often emerge as a sort of ad hoc institution to deal with the fact that the state could not keep up with the pace of private transactions. And so the ownership of land is turning over faster than the state registration can keep up with it. And so there's an extra household created to serve as the link between what is represented in the official documents versus who is actually managing the land. The second is that some of these pass-through households are intentional creations, often created by lineages to consolidate accounting and management of properties, especially properties that are used as ritual trusts. And I've actually been dealing with a fascinating example that I discovered over the summer, where a group of lineages in Huizhou created a tax account in the name of their ancestor who, if he ever existed, He had been supposedly had been a general in the late Han Dynasty. And so this was something like 1400 years later, they create a tax account in his name if this guy ever actually existed. And I tend to think that he was an invention. But nonetheless, he owned land and he owned a tax account. And so this was another way that these pass-through accounts could emerge. The third way that they emerged was to deal with defunct households, with households that had fled their tax responsibilities or that had died out or something else, and their neighbors were still paying their taxes, and they had to create a way to deal with this. And so we have all manner of pass-through accounts or sort of holding accounts that are created. And the other things up here are things that I've talked about a little bit. So shareholding, emerging in multiple forms of share through multiple processes, and the emergence of these ownership compacts and ways of dealing with conservation and upkeep responsibilities. So let's pause here for a second. So now we've looked at actually one of these documents, and I've summarized some things that we can see in some of these other related documents. And returning to the two historical problems that I've pointed out, there are two approaches that we can take to these documents. One is to turn to this question of how we go from none of these documents to loads of these documents. And so in other words, it's this question of how and why they decided to put each of these discrete things into writing. In other words, to see where these forest ownership claims are coming from. The second is to turn to this position where we have lots of documents and to try for synchronic analysis. To see, in other words, if we look at a cross-section of documents from a given point in time, if there is a rhyme and reason to the number and complexity of these documents at their peak. And so I'm actually going to do both of those things briefly. And first, I'm going to do the diachronic analysis. So I'm going to try to figure out where these ideas are emerging from over time. And in order to do that, I want to first look at a few theorizations of property rights. Because one of the things that is absolutely clear in looking at both Tanjing's document and at the documents as a broader body is that property rights are not one thing. They're a bunch of different rights, and in some cases, responsibilities that are bundled together. What theorists sometimes talk about as a bundle of rights or a basket of rights. And so there, I've encountered, and this is a place where, as a non-specialist, I would appreciate any further guidance that you experts can give me on this. But I've encountered at least 4 different ways of theorizing how property rights of this sort might be bundled together. So one comes from late Roman law, where there are these sort of separately conceived rights to usus, to the products of something. So in other words, the fruit of the land, the fruit of a tree, fructus, and the right to transform or destroy or use up something, abusus. And a lot of theorists have pointed to this last one, the right to transform something or to use it up, as critical in the development of more complete form of property rights. In American law, I think in sort of some Euro-American law, another way I've seen this theorized is to think about the different things you can do with something that you own. So possessing something is maybe different than controlling its use or enjoyment of its use, and also separate from the right to exclude people from it. And also the different ways that you might dispose of a property. So through sale, through rent, through inheritance, and so on. I've seen another theorization in international law, which is sort of more thinking about the different stages of the use or transfer of a property. So unbundling the rights into how it's acquired, how it's used, how others are excluded from use, and to the transfer. And I recently saw a Chinese historian or theorist, Long Donggao, give a talk where he gave a different theorization of property rights based on the Chinese experience, the Chinese historical experience, and in particular accounting for this idea of one field with 2 or 3 owners and distinguishing permanent ownership, which in the Chinese case was rather inflexible in both law and custom, due both to problems with land registration and to the custom of conditional sale. And so that was distinct from long-term possession rights, which were more flexible and could be securitized more readily into a sort of investment. And finally, to short-term tenancy and usage rights. And so I think that each of these theorizations reflects at some basic level what I just showed you in the record, what I just summarized from the record, which is that ownership is a basket of rights and we have to disaggregate them. And in fact, this is what people were doing. And what I'm going to argue is that actually there are at least three distinct ways that ownership claims originate. And so it is not just that we might theorize ownership as a basket of several different rights, but actually that these rights emerge from different processes and are consolidated into a more complete form of ownership. And each of these is suggested in the language that we've seen so far in this deed, and each of which can lead to a stronger and more consolidated form of ownership. So one of these is to take sort of the mere fact of possession of a property and develop from it a stronger claim to ownership, which I think is largely done through the investment of labor. And we've seen already this idea of labor shares. The second is to move from occupation of a property at one point in time to a more permanent form of occupation and ownership, which is a process that proceeds, I think, to a large degree through inheritance. And then the third is something that was key to several of these theorizations, which is the ability to exclude others from your property is maybe the key right to add to make a more complete form of ownership. And I think that this is tied in some really interesting ways to the idea of taboo, of religious taboo. And then the fourth thing that I'm going to talk about here is the way that these sort of private or temporary claims are made public or more long-lasting, which is, I think, really where this spate of documentation comes from. So, and so this is my first answer to why forest ownership is so complicated. And forest ownership is complicated because ownership itself is complicated. And so let's look a little bit at this process historically. And so the first way that I've asserted that we see some of these ownership rights emerging is through labor processes. There's the logic of labor, which is the claim to own things that you use or that you produce through your immediate labors. And most immediately, this applies to things like tools and to the immediate products of your work. And something that anthropologists have shown is that even in cultures that don't have especially strong concepts of property rights to things like land, they do have the concept of ownership rights to things like tools or to things like, say, if you cut down a tree, that you own that immediate product of your work, that you own that wood. And so the next step in making a claim to ownership is to claim not just the immediate product of your labor. So if you cut down a tree, you own that lumber, but a claim to own a standing forest. And what we see through this document is that this emerged explicitly in the Chinese case through the logic of labor, through the extension of a labor claim. And so this is sections from the biography of Yang Xi, who was a mid-5th century statesman in southern China, and he argued there was at the time a law on the books which said that people could not occupy mountains or marshes permanently. And so this was basically meant that land other than farmland, including forests, including fields, including streams and lakes and things like this, could not be owned, essentially, could not be occupied long term. And Yang Xi is arguing against this, that this law needs to be amended. And what he says is that where there are mountains and marshes, where there are these wild lands, where there has been long-term clearing or planting or cultivation of forests with bamboo or wood or other assorted plants, or in places where labor has been consistently invested in maintaining fish ponds, or lakes or seas or fishing grounds, these are not going to be confiscated. And so this is a classic pre-modern Chinese legal formulation where instead of getting the positive formulation of the right to own, Yangshi is not saying we're going to give you ownership rights. Instead, what he's saying is we're not going to confiscate your land. And that's actually the form that we see this taking in most pre-modern Chinese law, is a sort of negative formulation that it's not going to be taken away by the state. And so that means that there is sort of de facto an ownership right. And then Yangshi goes on to say, for each rank of official, you can establish a quota for how much forest they can claim and record it in the registers. And so essentially what he's arguing very explicitly is that people should be allowed private ownership of forests, not just the trees that they cut, but the trees that they may have planted or the areas that they may have cleared or cultivated in some other way through their labor, that they can derive some longer lasting claim to those properties. And in fact, what we see is that labor does create a forest that is recognizably different than a natural forest. So here are two pictures of forests from relatively nearby areas in Fujian province. On the left, we have a natural forest, which is sort of recognizable from above. It sort of looks like a head of broccoli. And, it has this sort of fractal shape to it. And on the right, we have a tree plantation, a forest that has been modified and planted by human labor. And with enough time, these man-made forests, these anthropogenic forests, don't necessarily look that different than natural forests, but at least when they're young, they do. They're recognizably different. And so a tree plantation is therefore easier to claim than a natural woodland. And so using things like Yangshi's biography and the Tang Code and some things that happen in the Song Dynasty, we can reconstruct a much deeper history of labor-based claims that predates the type of labor shares that we see in forest deeds going back to, say, the 1500s. Nonetheless, the 12th century was a clear turning point where forest ownership became much more widespread. And again, the 15th or 16th century is another turning point where it becomes significantly more widespread again. And I will return to that in a moment. So the second place that we see claims to ownership is through inheritance. And if we trace these back far enough, there is an initial claim to occupation of the land, dating back in some cases to very early ancestors. And if we go back far enough in time, these stories of ancestral claims merge in many ways with the realm of the sacred. And in fact, I'm going to build on David Graeber and David Wengrow and some other scholarship to argue that this ability to exclude other people from your property is very much attuned to the idea of taboo, which in the original meaning of the word taboo literally means not to be touched. And so if something that you own is something you can exclude others from, it is something you can keep them from touching. And that's very much attuned to this concept of sacred spaces. So we find sacred forests, taboo forests, if you will, across the historical record. And so here are some examples. On the top left, sorry, that's mislabeled. You find this is a Hindu sacred grove in India. The bottom left, this is a Shinto forest in Japan. In the bottom center, this is an Ethiopian Christian church with a sacred forest around it. And on the right, this is a really interesting document which depicts the ancestors of a Mayan king, from present day Mexico, who depicts his ancestors as orchard trees. And scholars think that this implies that the Mayans would have cultivated orchards as sacred forests as well. And in China, forests and trees are closely tied to taboo from very early history. So this is a Han tomb tile, and what it shows is a sacred tree. In this case, it's very clearly a conifer. It looks, a little bit like a Christmas tree, a child's drawing of a Christmas tree on top of an earth god shrine. Um, and so these shrines were sites of very strong religious taboo. They were also connected to ancestral graves. And in fact, if we go back early enough in the documentary record, earth god shrines and tombs may have been two branches of a single tradition. It may have actually been that putting ancestors under the earth turned them into some sort of earth god or earth spirit in the earliest form of this tradition. And then it eventually diverges into two traditions, both of which involve planting of sacred trees or sacred forests on top of these mounds, one of which is the earth god shrines, the other of which is the ancestral tombs. And there's a very strong taboo against cutting the trees on these shrines or these tombs. And lo and behold, it is in these same tombs that we find the earliest recognizable land deeds in the Chinese tradition. Some of these date back to the 2nd century BCE. The example that I have here is from the 1st century of the Common Era. This is just something that I saw in the Shanghai Museum over the summer. And these deeds are not only far earlier than any other known land deeds, they are far earlier than almost any other known contracts in the Chinese tradition, except for debt contracts. And so, in other words, the oldest properties with written documentation of their ownership are tombs. And so they are therefore sites of taboo. And so deeds start out as objects recording ownership rights to graves and recording some of these grave taboos. They note that graves in this case had been appropriately purchased from the gods and spirits. And so they give the origins of the chain of title, which originates not with the first human occupant of the space, but in fact with the gods themselves. And then we have the sacredness and taboo of the sites made explicit. In many cases, the grave deeds note that they exclude not only the living from the sites, but also any future burials. Some of them will, in fact, say if anyone in the future is buried in this same plot, they will become the slaves of the first inhabitant of the tomb. And these are really fascinating texts. I went down a little bit of a rabbit hole thinking about them. This is far earlier than my research usually goes, but they're totally fascinating. They look astonishingly like the land deeds that we see from the 12th century onward, complete with the locations, with boundaries, with prices, with usage clauses and exclusion clauses, and even lists of scribes and witnesses. And the only thing that seems strange to us, perhaps, is that the prices are almost always, they're either fictitious or they represent spirit money, maybe paper money that was burned, because the prices are almost always long strings of nines, $99,999 dollars or coins or what have you. The other thing that's unusual about them, maybe from our modern perspective, is the scribes and witnesses and sellers are gods and spirits, and at some time become fixed in this sort of interesting pantheon. But we have to skip forward over 1,000 years before we find similar documents used for production forests. And so unless the archaeological record is horribly misleading us, what this means is that deeds to production land borrowed the form of grave deeds and not the other way around. And that the claims to exclude others from land were first legitimate when they were built around burial taboos and ancestor worship, and were only later spread to the more temporal economic realm. Not incidentally, as this limited taboo that we see in early grave deeds became more widespread, and the right of exclusion was extended to regular farms and forests and ponds and things like this, taboo itself changed. It became a much more complex realm of feng shui, which was the topic of my presentation last time, and it gives birth to this whole other body of documentation that I talked about a little bit last time, and I will not have time to go into today. But what this means to me is that if the first support of ownership claims comes from labor, the interconnection of taboo and inheritance claims is the second support of ownership claims that we see emerging from the historical record. And so now we have to come to this question of how to make these rights claimed on the basis of occupation or inheritance or taboo more durable, more transferable, and more generally recognizable. And so the answer, I think, in how these were made to last, and how these sort of different trajectories, these different lineages of ownership were made more permanent and more generalizable, lay in documentation. And so we've seen that both labor-based and occupation-based ownership had forms of documentation even in earlier periods. We saw official registers, land registers in the biography of Yangshi from the 5th century. We saw private land deeds from the grave deeds dating back to the 2nd century BC. And what we see next is the spread of these forms. And it appears, and here I'm following the scholarship of Du Zhengzhen, that private forest deeds spread from graves gradually to temples and then to production forests between the 10th and 12th centuries. And so we see gradually the elaboration of a form from the tomb vault to the ground above the tomb, and then to the surrounding plot, and then, and only then, where they spread to production forests by, say, the 11th or 12th centuries. As I myself have written, there was an overhaul in the land registration documents in 1149. This was a really important overhaul in land registration documents. It did a number of things. One of the things that it did is to say that instead of assuming a simple rectilinear form for a plot of land, you actually have to survey the boundaries. And this was really important in surveying land in southern China, where the land is not so flat, and so the land boundaries might not be so simple and orthogonal. The second thing that it does that's really important is that all of a sudden, after this 1149 law, tens of thousands of acres of forests were suddenly appearing in the state land registration documents. It goes from almost none to thousands almost overnight. And so this hinged on a new definition of property that explicitly included forests. And so this, I think, is when we see the emergence of forest ownership from its hazy prehistory into something like a recognizable history. While not all of the documents from this period are extant, there were registers and deeds that look fairly like modern land registers and deeds documenting forest ownership from the late 12th century onward. And this hinged on a redefinition of what ownership could be, spreading from products of one's own hand to the land that one cultivated, spreading from sacred properties to economic properties. It also hinged on a redefinition of what a forest is. In Chinese, shan, literally meaning mountain, became the preferred and specialized term for forests cultivated by human hands. In other parts of the world, forest was likewise redefined as forests became things that could be owned. In France and England, for example, forest used to mean a type of land that someone, usually the king, could privately own for the purpose of hunting. A forest was, in England and in France, a place of deer, not necessarily a place of trees. And in fact, some of the most famous forests in England, the forest of Dean, for example, were not necessarily heavily wooded. They were places where the king went hunting. But when forest ownership became a more standard thing, forest gradually became the term of art for a property owned for the purpose of producing wood. And this is actually, as a little bit of an aside, where we get the modern use of forest as an ecological term. The first people to think about forests ecologically were the officials tasked with overseeing these new forms of forest properties. People like Heinrich Kotte and some others whose names are escaping me at the moment. And as they begin to develop the science that would become forestry science and ecology, forest goes from being an administrative term for a particular type of property to becoming an environmental term for a particular type of land cover. And so we can see examples of official policies leading to new forest claims around the world. This is essentially the golden spike of forest history. Before the policy for the state to register forests, there's very little documentation, and this probably reflected one legal regime and also a corresponding social ecological regime, one dominated by mixed-use, wild-growth woodlands that were treated as common pool resources. And after the policy to register forests, to document forests, there is tons of documentation that probably reflected a new legal and socio-ecological regime, one increasingly dominated by specialized use, human-planted forests treated as private or state property. And so I'm going to take you on a whirlwind tour of some of these new forests. So this is a relatively famous example from Nuremberg in central Germany, which is outside of China, as far as I know, the earliest known place to plant conifers on a large scale. It was seen in Nuremberg as early as the 14th century, and in, I believe, the 16th century, 15th and 16th century, as Nuremberg felt it important to consolidate their control of these forest holdings, especially with respect to surrounding aristocrats. We see the emergence of forms of documentation like this. Here's another one from Nuremberg, and this documents not only the ownership of these forests by the city, contrary to other claims, but it also shows that these forests were divided into different sectors, which fell under different forms of management. Here is another one of the other very earliest examples. This is from Venice in Italy, which aside from Germany and China and I guess maybe Spain, is one of the other earliest places in the world that we know of to produce this type of documentation of the forests. And this is again because the forestry authorities in Venice wanted to exert control over them. And then when we get into the colonial period, these forms of forest maps and cadastres and ownership claims spread around the world. So this is a sketch map of British forest reserves in Burma. And there's a very interesting story behind this one. In the early British forestry service in India and Burma, they mostly used German-trained foresters. And the name of this one is escaping me at the moment, but he was sent on the back of an elephant to ride a transect route through the forests of Burma, basically paralleling the Irrawaddy River. And he had two sticks. And on the stick in his right hand, when he saw a teak tree of sufficient size to be used by the Royal Navy, he would make a notch. And in the stick on his left hand, when he saw another tree of economic value that was not teak, but of some economic value and of sufficient size, he would make a notch. And so he rode one transect through the forest and made notches in these two sticks, and then extrapolated from that to estimate the amount of useful timber available to the British Crown in Burma. And so the production of these documents is very much oriented towards these claims to own and control the resources. And it was not just the Europeans or the European colonial powers. Here is a forest map of colonial Korea. from early in the Japanese occupation, early in the period of Japanese control. My good friend David Fedman has written an excellent book about Japanese forestry in colonial Korea. Here's one from the Netherlands, the Dutch colony in Sumatra, doing a similar thing. Here's one from the French colony in Tonkin in what's now northern Vietnam, and so on. Okay, and so to return to this question of why was forest ownership complicated, I think the answer that we get from this diachronic picture, this look over time, is that forest ownership is complicated because ownership is complicated. Ownership is not one right, it is a basket of rights. Ownership does not have a single origin, it has multiple points of origin. And so what we see as the emergence of forest ownership is not actually the creation of new rights, but rather their bundling together and their documentation in a relatively standardized regime. Nonetheless, we get a roughly one-to-one correspondence between a changing legal institutional regime and a changing social ecological regime. When forest ownership is defined as a discrete bundle of rights tied to a discrete bundle of documents, we suddenly get documentation of forests. Or to flip this around, I've argued that when we suddenly see documentation of ownership, it's because forest ownership has been solidly bundled together for the first time. And that also means that people are transforming those forests in new ways. They are increasingly using them for certain specialized uses. There's more human labor inputs and things of that nature. And so I thought that this is what I thought anyway. I thought that this was the end of the story when I wrote my first book. And the problem is that forest ownership is not just complicated because ownership is complicated, it is worse than other forms of ownership. So we've seen many of these complications of ownership that I talked about at the beginning in not just forests, but also in farms. So we see long-term tenancy and this idea of two lords of the field or three lords of the field, not just in forests, but in farms as well. We see conditional sale and living sale and renegotiation and all of these things, not just in forests, but in farms as well. We see pass-through tax accounts and all these other forms of sort of corporatized accounts in farms as well. But forest ownership is more complicated than farm ownership. We don't see shareholding very much in farms. And we don't see this delineation of conservation and upkeep responsibilities as much in farms. And so this suggests that forest ownership is complicated, not just because ownership is complicated and it's a basket of rights with different points of origin, but also it's complicated because there's something uniquely complicated about forests. And so my second answer to this question, why is forest ownership so strange, so complicated, is that it's because forests are complicated. So to talk about this, I'd like to do some theory again. So economists sometimes find it useful to classify goods according to their exclusivity and their competitiveness. And so if we think about classes of goods where exclusion is easy versus exclusion is hard, and then that are easy to use up and that are hard to use up, by hashing these together, we get four categories. So first, we have private goods, which are things that are easy to use up, but it's also easy to exclude other people from them. And so a rather trivial, but I think nonetheless useful example of this might be my sandwich. If I eat it, you can't eat it, right? It's easy to use up. If you eat it, I can't eat it. It's used up. But it's also easy for me to exclude you, to say, hey, that's my sandwich. You can't eat it. And so more broadly, it's not just sandwiches, right? There are loads of things that are private goods. Tools I mentioned earlier, things that are products of your own labor. It's easy to exclude people, and it's easy to use them up. Um, at the opposite corner, we have paradigmatic public goods, which tend to be things like air and water. And it would be very hard for me to stop you from breathing. So exclusion is hard. But on the other hand, except in very extreme cases, my breathing does not impinge on your breathing. And so it's not hard to use up. And so we get this category of public goods. But the two other corners have these other sort of strange mixed cases. So club or toll goods are cases where it's easy to exclude others, but the thing is not easy to use up. And an example of this would be membership in a club or something like participation in this seminar. So having more people in this seminar doesn't use it up, right? We can have 10 people attending this seminar or 100 people attending this seminar, and it doesn't change or negatively impact the if it is actually a good, this seminar. But on the other hand, it's very easy for the administrators of the seminar to exclude you or to kick you out. And we have a fourth category of goods, which are common pool goods. And those are goods where it's relatively hard to exclude people, but it's also easy for the good to be used up. And traditionally, this is the category where forests are placed. And so, again, private goods, things like sandwiches or tools. Public goods, things like air. Club goods, things like this Zoom seminar. And common pool goods, things maybe like forests. And so these things that are easy to use up and hard to exclude others from are a problem. And in the mid-20th century, there were two diametrically opposed ways of thinking about the problem of common pool resources. Probably the more famous of these is the so-called tragedy of the commons that was posited by the ecologist Garrett Hardin, who argued that because it was hard to exclude people from common pool resources, they would be easily used up. And so, in other words, the tragedy of the commons is that because you can't exclude people, it would lead to overuse. There were some others, especially sort of free market economists, who argued that actually the problem of the commons was not overuse, but underuse. That the problem of the commons was that if it's no one's individual property, they're not properly incentivized to use it to its maximum extent. And so actually the problem of the commons is inefficiency and underuse rather than over-extraction and overuse. And so the seminal argument of Elinor Ostrom in the 1990s was that, in fact, common resources could be adequately governed with a handful of relatively straightforward criteria. And so here are Elinor Ostrom's 8 principles for commons regulation. You need clear group boundaries. You need to match the rules governing the commons to the local needs. The rules need to be able to be modified by those affected by them. The rights should be respected by outside authorities. There should be a system for monitoring with graduated sanctions for rules violations. There should be dispute resolution at relatively low cost, and the responsibilities should be in nested tiers. Okay, so that's incredibly useful, and Ostrom and some of her collaborators later applied. In fact, one of Ostrom's central examples, her 2 main examples were forests and fisheries, and she, with collaborators, later applied this in even more detail to forests. The question that I have is, are forests actually common pool resources? So, sorry, before I get there, yes. And so going back to the documents that we saw, what we in fact see is that in Chinese forestry documents, they match her principles for management quite well. We see clearly defined group boundaries. The rules are matched to the local needs because they're written by the locals. And they're modified by those affected. They're respected by outside authorities. If you bring a deed or if you bring an agreement into the court of the county magistrate. He will enforce that. There is a system for monitoring, both within the local community, and frequently it calls for the outside authorities. Whether these last three characteristics, these last three principles are met, sort of depended on the individual case. In some cases, the sanctions are graduated. In some cases, they're not. In some cases, there are provisions for lower cost dispute resolution. In some cases, dispute resolution means going to the magistrate, and that's very expensive. And in some cases, there are nested tiers of responsibility, and in some cases, there are not. But in any case, like, it does seem that the historical Chinese context did give rise to Ostrom's 8 principles for commons regulation. Nonetheless, I want to raise the question of whether forests are actually a common pool resource. And so, because forests are not just one resource. And to think about this, I think we need to disaggregate forest resources in maybe a way akin to how I disaggregated the idea of ownership. Because there are actually many different things that people derive from forests. And I call these the 10 Fs. This was originally the 6 Fs, and then I kept thinking of more things, and so now it's the 10 Fs. And so one thing that people take from forests is food. You can collect fruit and nuts and tubers and game, and you hunt game, you can collect mushrooms. The second thing, probably historically the most important thing that people took from forests, was fuel. The German forest historian Joachim Radkau has estimated that historically 90% or more of wood usage was for fuel purposes across long periods of history. The third thing, which to make it an F, I call frames, refers to large timber or bamboo. So you need wood to build structures. You also need wood to make tools, to make ships and bridges and things like that. Number 4, fodder. So grazing animals, and in the Chinese context, also collecting mulberry leaves to feed to silkworms is historically important. The leaf litter and other things that fall on the forest floor can be gathered to fertilize fields. There are too many pharmaceuticals to name. Aspirin originates from willow bark. Quinine originates from a tree bark, and there are dozens or hundreds of pharmaceutical chemicals that derive from traditional Chinese medicine products gathered from the forest. Fibers for forests products are also used for thatching, for making twine and rope, for making paper pulp, and other fiber-based products. They're used as factory inputs, including things like tung oil, camphor, and lacquer. Forests are also sites of what are sometimes called cultural services. And to make it an F, I'm calling this faith. So in the Chinese context, they are sites of earth gods and ancestors and feng shui. They're also sites of recreation and things like that. And forests also perform ecological functions. They do things like water filtration and carbon sequestration and provide habitats for wild animals and plants, things that we now increasingly see as significant. And so here are some pictures of this from the Chinese context, so we can see foods derived from the forests, things like lychees and bamboo shoots. Fuel was clearly historically important. Large timber and bamboo for construction. To the right, South China's most important tree is the China fir, shamu or shanmu, Cunninghamia lanceolata. Fodder for animals, including for feeding silkworms, fibers, including for making paper, a whole number of chemicals that go into industrial purposes, like making ink or camphor or waterproofing things. And then also, this is a giant ancient camphor that is still an object of faith. These are wish ribbons or prayer ribbons tied to it from my visit there this summer. And so I do think that in the before we see this golden spike of documents, forests are largely common pool resources, that most of these products are obtained from a common forest where people from the community all share the right to go in there and harvest goods that they need, but nobody is permitted to own the forest itself. This includes people going there to collect food. It includes people going there to cut trees to use for framing their houses. And it includes all manner of other products. But there are also some goods that are already in the public goods or club goods section. And we see similar things in Europe, where forests were historically used for a mix of different uses, including hunting. But even on hunting land, peasants were also still allowed to collect fuel and to pasture their pigs and things like this. And the Charter of the Forest, the accompaniment to the more famous Magna Carta, was a document assuring these rights, essentially enshrining forests as a common pool resource. But I think that actually what we see is that the complaints of Garrett Hardin and these other theorists are not wrong. There's both a tendency towards underuse and overuse of forests, depending on what resources you're most interested in. And so there's a push on the one hand to privatized forests, done largely to promote efficiencies in producing certain goods. There's also a push to restrict certain forests, done in the service of public goods like erosion prevention and other things like national defense. And there's also some exclusionary moves done for sociocultural reasons. And so many of these forest goods framing industrial fuel move into the category of public goods. Other of these goods produced by forest move into the category of private goods. Others move into the category of public goods. And there are two notable features of these movements. The first is that each claim that moves a forest good out of the common pool resource creates a paper trail. And that is, in fact, what we have been looking at today. Privatization creates a trail of deeds and tenancy contracts and land registers. And restriction creates its own paper trail of prohibition, inscriptions, and the like. And with the movement of some of these goods out of the common pool resource box, the remaining common pool resources needed to be protected against either privatization or overuse by the types of regulations that Eleanor Ostrom talked about, things like community compacts. And any further updates to the ownership, to the regulations, to the disputes, created a further paper trail. The second feature of these movements out of the common pool resource box is that the new regime retained features of common pool resources. So for privately owned forests, for privately owned timber in particular, we see features of the common pool resource regime in the fact that they are distributed as shares. Shareholding was a way of subdividing the resource among a community of users, albeit a way of doing so within a private property regime instead of a common property regime. For protected forests, this feature of common pool resources is seen in exceptions to the regulations. For example, the continued right to collect fuel in protected forests. And so, in other words, what I'm arguing is that the complexity of forest documents is not an accident. It's a reflection of the fact that forests are complex themselves. People wanted to use forests for lots of different things, and the contractual complexity, especially with regard to shareholding, layered management, and usage regulations, reflected the fact that forests were not just one good, they were many discrete goods. The subdivision of forest rights, in other words, reflected the fact that forests were actually many different things. So to recap, how do you own a forest? The answer is quite complex, but this complexity is not an accident. Forest ownership is complex because ownership is complex. It's not one thing, but a basket of things, and it does not come from one place, but from several places. I've argued that exclusive ownership claims derive from labor-based claims, from inheritance, from taboo, and from documentation. So we should not be surprised to see the legacies of each of these lineages in ownership show up in the documentary record. Second, forest ownership is complex because forests are complex. They're not one thing, but a community of many things, of different plants, animals, soils, waters, etc., that even from a human perspective, there are often public goods, private goods, common pool goods, and club goods, all on the same plot of land. Third, it is clear that ownership both documents and enacts a transformation. Owning a forest produces documents. It also produces changes in the land. As common pool goods are privatized, the owners get good at producing things that they own, generally timber and fuel, and later things like paper pulp, but they stop caring so much about things that they don't own, which includes things that other humans use, like food, household fuel, grazing land, and so on. But it also includes things that non-humans use, things like wild animal habitats, soil retention, carbon sequestration, and so on. And so there is some good news here. I think the good news is that the mixed forest, the common pool forest, did not go gently into that good night, or more to the point, the stakeholders did not. They struggled against privatization, and forests in China were not fully privatized, nor for that matter were they treated as fully private goods. They were sort of both and all of these things at once. And so if I may be permitted to end on a sort of editorial note, I think that this offers a lesson for us in the present. We face a climate crisis, we face an extinction crisis, we face a habitat loss crisis. All of these things hinge to varying degrees on the forest resources that we have. So there is a temptation among environmentalists, and I consider myself an environmentalist, to want to place large segments of forest land off limits to development and to human use. Yet there are also a lot of things that we need from the forest. We still need framing timber. We still need industrial inputs. We need forest pulp. We need paper pulp and things like that. We don't need fuel so much as we used to. But in any case, what historical China shows us is that we can, in fact, do both. We can do both in a way that is not perfect for any particular purpose. We don't necessarily maximize timber yields, nor do we preserve the maximum amount of habitat for other species, but we get a useful compromise. How exactly do we do this? I'm not a policymaker. I'm not a lawyer. That's a problem for you folks. But here is what I will contribute as a historian. This compromise has multiple parents. It recognizes labor, and it also recognizes sacred taboo. And perhaps it also needs to recognize modern sources of value such as ecology and economic theory. So thank you very much. And that is where I will break for questions.
Great. Thank you very much, Professor Miller. This was a fascinating talk. I have 2 pages full of questions. But of course, if anybody in the audience has any questions, please remember to chat them in. I have already received some questions, and the first one comes from Yan Li. So far as I know, there was a system of one field with 2 masters. I think you mentioned that also in the Qing dynasty. It's not official, but popular in the South. That is, the 2 different rights of a piece of land were divided, right of the bottom of the land and that of the surface of the land, both of which were property rights with complete and independent powers. I just wonder whether such a similar system existed in forest ownership.
So this is largely right, largely correct. I would sort of explain further that while it's often referred to as a surface right and a subsoil right, what is referred to as the surface right is actually essentially a form of very long-term tenancy, what's sometimes referred to as permanent tenancy. And I don't think that the issue of the surface rights versus the subsoil rights became a stronger concern until mining interests became a really big deal in the late 19th century. But yes, this to answer this question, this issue of one field with 2 owners, or one field in some cases with 3 owners, you see in forests as well, absolutely. And so In the case of three owners, what you will often see is there's one owner, which is basically a pass-through tax account. And so that is the name under which taxes are paid to the government. And perhaps that person obtains some limited amount of rents for that right. But it's otherwise very superficial. Then you have some form of long-term or permanent ownership. And then you have some form of shorter term tenancy. And as we've seen in earlier parts of this presentation, that the first one was fairly rigid. The first ownership form was fairly rigid, but the other two forms, the sort of long-term or semi-permanent tenancy and the short-term tenancy, were fairly flexible and could very much be securitized. So they could be subject to advanced sale or to subdivision into shares, or into bundling into these groups of shares. And this is where Joseph McDermott has argued that calling this tenancy rights or ownership rights sort of confuses what is actually essentially an investment vehicle. It's essentially a form of security. I think that he maybe went a little bit too far in this because in some cases it still very much refers to actual sort of ownership and usage forms. But nonetheless, the short answer is yes, absolutely we see that. And in fact, it is in many ways more complicated with forests than it is with fields.
Thank you. Next question. You mentioned the hundreds of thousands of registration documents. How do you move forward to analyze these documents systematically? And can AI help?
Okay, so I'm going to go back to this slide of this box. And so this, wow, it's way at the beginning. So this is a really interesting problem. And so even for my generation, and certainly for earlier generations of historians, we were used to dealing with a problem of relative scarcity. And so we had to sort of figure out what we could from the limited documents that we have. And now there are so many of them. And in the short term, what I have seen being done with these is still applying the older methods. And in fact, applying maybe better developed versions of the older methods, which is to read these in context. And so very much to go into the village, to go into the home, and to see how these documents match up to specific places and how they match up to things in a genealogy, and in the family relationships and things like this. And that type of what we historians call close reading, or sort of contextual reading is incredibly valuable, but it's not up to the task of tens or hundreds of thousands of documents. And so my mentor, Michael Soni, has very much been pushing for, as these get digitized, to be more easily accessible, that they be opened up to these existing and up and coming digital methods, including opening them up to full text search, and in particular, opening them up to artificial intelligence. And I don't know that we yet have the technology for that specifically, but I do know that there are people working on it. So a good friend of mine, Javier Cha, who teaches actually at HKU, is currently working on training a model specifically on historical Chinese documents. So an AI, in other words, that is not a general purpose or built off of the sort of web like ChatGPT is, or something like that, but that is specifically trained on historical materials in classical Chinese, in pre-modern Chinese. He is more interested in a different set of documents than this, but I think that this would be a really exciting frontier and probably a necessary one if we are to make full use of this range of materials that we have. And so I should say that it's exciting days. I mean, there are already, we're already able, there are all these things that historians of Europe used to say, oh, well, European law has this, this, and that, and Chinese law didn't have it. And guess what? They were wrong. They were wrong about almost every one of those things. We just didn't have the documents to show that yet. And now we increasingly do. And so that is already exciting. And that can be done with these sort of individual, highly contextualized case studies. But if we really want to get a richer, either synchronic analysis, cross-sectional analysis, or diachronic analysis, analysis over time, we need to hook it up to a more powerful engine. And that means the use of digital tools. One final thing that I will say on this is that there is a severe bottleneck in this, and that bottleneck is the digitization process itself. Once you have a computer readable text, computer scientists and computational linguists know how to do this stuff. They know how to do neural networks and AI and all this, cool things that are way over my head. But getting the computer to read the text, the OCR, the optical character recognition, is still not wonderful. And so the bottleneck is that if you want to have a good quality digital document to work with, they're still mostly hand keyed by people and not read direct, or at least hand corrected by people. As I understand it, the best hit rate for Chinese OCR is still in the mid 90, like it's around 95%, 90 to 95%, which sounds good, but that still means that 1 out of 20 characters is wrong. And that's actually pretty bad in terms of readability, and especially in terms of digital analysis. But that's a great question. Thank you.
Thank you very much. I'm quite optimistic about the possibilities that AI will produce in the future. And I also assume, and that's probably the last question before we have to close. Actually, it's not a question, a comment. I assume that the language in these documents is rather similar and rather simple in the sense that it's repeating the same characters. There is not too much variation. Half a sentence from you only, because we need to stop.
Yes, so that's absolutely correct. At one level, they're highly formulaic documents. On the other hand, because so many of these were written by people who were not formally literate, there are a lot of non-standard characters. Yeah. And so the answer is both yes and no.
Yeah. All right, then thank you very, very much for a fascinating talk again. It was great to have you with us. Thanks to everybody, and have a good afternoon. Bye-bye.